The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the Micklin Law Group's monthly webinar series. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters with offices in Nutley, Montclair, and Saddlebrook, New Jersey. For those who haven't worked with me in the past, my name is Brad Micklin. I am the managing member and lead attorney for the Micklin Law Group. I've been licensed to practice law since I think it was 1995, which gives me about 25 plus years of legal experience. Started my practice as a judicial law clerk for the Honorable Eugene Austin Special Civil Part of Bergen County. Moved on to David Kessler & Associates, where I did complex commercial litigation for a couple of years, and then transitioned in about 2000 to my own firm, which is concentrated in empowering men and fathers in divorce, custody, and family law matters. We proudly have offices in Nutley, Montclair, and Saddlebrook, New Jersey, and are currently working remotely following the COVID quarantine. Since it's currently winter, I'm recording this in December of 2023, which is important to note if you're watching this in any other state than New Jersey or at any other time much later than December of 2023. You always want to check to make sure that the information has been updated. I do try my best to stay away from what we call black letter law in these webinars and instead give you more practical, pragmatic advice about what to expect. But nonetheless, you still want to keep up with it. So let's talk a little bit more just for my background in case you haven't ever worked with me. These are some of the words I've been honored to receive both from client and peer recommendations and reviews. I put them here not to impress people, but to impress upon you that I have been doing this a long time. I do believe my knowledge is helpful, and I do hope you get value from it. I also serve from time to time as national legal consultant. I've appeared on Fox News, Larry King Live, when he was with us, obviously, Inside Edition, and many other national and local news sources. Again, not trying to impress people, but just to give you a sense of the variety of experience that I bring to the work I do. As I said, I try to be both legal and pragmatic in my advice to my clients. Today's webinar, 7 things to know before meeting with a New Jersey divorce attorney. Welcome to hopefully an engaging and informative presentation on what to know before meeting with a New Jersey divorce lawyer. So let's dive in. First, overview of the divorce process in New Jersey. Top 3 things most important to know. Grounds for divorce, number 1. Understand the different grounds for divorce in New Jersey, including adultery, reconcilable differences, and more. I believe currently there are about 11. The most common are irreconcilable differences, which has a 6-month waiting period. That is most common because it's the closest thing that New Jersey offers to a no contest divorce. Second is extreme mental and physical cruelty. And that, quite honestly, is often because people come to a divorce very hurt. Many are victims of extreme mental and physical cruelty. I'm not trying to minimize what people go through when they come to file a divorce. But the grounds for the divorce and the paperwork are not as important as many clients think. They can be. That's long past the scope of this webinar. I believe my YouTube page and my website, micklinlawgroup.com, which is MICKLIN, lawgroup.com, will have webinars going through more specifically. But it also has a very short waiting period. Adultery is the only ground that does not have a waiting period. I believe historically that's a lot due to, well, I won't get into what I think it is. But nonetheless, adultery has no waiting period. The waiting period means you can't just run to file for a divorce at the first sign of a problem in New Jersey. I believe the intention overall was precisely that, to keep people from running in at the first sign of a problem. However, with the implementation of irreconcilable differences, you can't necessarily run right in. You still have to be married 6 months, but it's a lot easier. I think extreme cruelty is 3 months. So the statute and the state is no longer making you wait that long if you find being married to be disfavorable to you. 2, legal separation. Learn about the process of legal separation and its implication for divorce proceedings in New Jersey. I put this here specifically because New Jersey does not necessarily have a formal legal separation, and many people ask about it. As a side note, I do have what seems to be a very popular webinar on my YouTube page. Again, maybe on my website, but my YouTube page is more robust. Misconceptions, common misconceptions in a divorce case, and that is one of them. People are often asking about legal separation, so I wanted to touch upon it here. Technically, there is nothing formal. There are 2 methods in New Jersey I'll touch on briefly that are akin to legal separation. The first is receiving a temporary or a final restraining order that does physically and legally separate you, although it does not divorce you. So it could work as a legal separation. It is technically the closest thing New Jersey offers to that currently. The second option is a separation agreement, more commonly called a post-nuptial. Again, I have a webinar for that on my YouTube page. I'll see if I can add links to some of these below if you do want to see. Let me just make a quick note. Misconceptions, grounds for divorce. So a post-nup is like a prenup, just it's done after your marriage, and it is an attempt to delineate or isolate your legal responsibilities from one another. If you do not wish to get divorced, sometimes called a reconciliation agreement or a mid-marriage agreement. It's got a lot of different terms. The thing to know briefly, although I won't go into it in depth, is the law does not necessarily favor them for many reasons, or I shouldn't say favor them, but they're challenged a lot more easily than a prenup. And I know most people believe prenups are easy to challenge. Again, a separate issue, but and that's not accurate. So I do have a webinar on that also. But they're frowned upon, so it's important if you're going to seek a post-nuptial agreement to make sure you understand the law around them so that you do enter one that will be enforceable. And lastly, on the overview of the process, division of assets. We want to discover how assets are divided in New Jersey, including property, finances, and other assets. It's important just with the distribution of assets and debts to know that New Jersey is not a community property state. It is an equitable distribution state. Equitable does not mean equal, so it does not mean that you get 50% of marital assets, although quite honestly, that is sort of the starting point and the ending point for most cases. But that also does not mean that even if you are getting 50% of every asset, that we're just cutting everything in half or selling everything and dividing the proceeds in half. There are a lot of other considerations like premarital assets, tax consequences, accessibility, like to retirement assets as opposed to liquid assets, capital gains taxes. These things need to be contemplated and equalized if you are going to be distributing the assets under equitable distribution. Next, you want to know important documents and information to gather prior to your consultation, or at least find out during your consultation what documents and information you will need to gather to make the process flow more easily. First, financial documents. You want to learn what financial documents to gather, including tax returns, bank statements, and investment records. The types of documents and the amount will depend on your case. You want to also find out, based on the complexity and length of your marriage, how long or how many documents you need. You will need, obviously, like I said, tax returns and bank and credit card statements, retirement accounts, but you may need 2 or 3 years if you have a short-term marriage. You may need 10 years if you have a long-term marriage. And the more you need, obviously, the more difficult to obtain. So find out during your consultation. Next, asset and debt information. Understand the importance of documenting assets and debts such as property, mortgages, and other credit card debts. When it comes to asset documentation, again, it's going to depend on what assets you have, the nature of them, and the length of your marriage. Additionally, you want to look to get like closing statements, the HUD statements if you have real estate. You might even want to consider getting appraisals for any valuable property, any business interest now, before you actually begin the process, or at least find out from your consultation when you should either get the evaluations or appraisals or start to interview people who would give you the evaluations or appraisals. Lastly, child custody information. Be prepared with information about your children, including their schedules, medical history, and educational needs. If custody is going to be an issue, and always go into a divorce assuming that it is going to be an issue, meaning if you have children, it's an issue. You also want to know things about like their school information, their friends, their teachers, their extracurricular activities, their interests, and their social security numbers. A lot of times people come in and they don't have this basic information. And if you are seeking equal custody, if you're seeking sole custody, which we'll talk about a little bit later, you want to be able to be knowledgeable and fluent in all the information regarding your children, from their medical needs to their friends' names. Everything will be important. Questions to ask during your initial consultation. First, experience and expertise. Find out about the attorney's experience in handling divorce cases and their expertise in New Jersey family law. Now, I don't say this because I am an attorney who concentrates in divorce and family law, but my personal opinion is to always use an attorney who only handles the areas of law that you need. Don't go to your real estate attorney. Don't take a referral from your personal injury attorney. Don't think being an attorney makes you fluent in all areas. It doesn't, in my opinion, unless you do a high volume of all of them, but in my opinion, you can't do everything well. And even though you may not have a complex case and think that you need an expert, you're probably mistaken. I should put a caveat. Unless you know that you have a amicable divorce coming, you have a reasonable spouse, your expectations have been discussed, and you have some sense of where you're going. But even then, I would still say consider somebody who concentrates in divorce. While it might be more expensive initially or appear to be, I think cheap is never cheap, and you're better off getting somebody who knows what they're doing. They'll be better at the issue spot, and they'll be more fluent in their preparation, and they'll probably be more streamlined in the management of your case, which overall translates into savings. Second, case assessment. Inquire about the attorney's initial assessment of your case and a recommended strategy for achieving your goals. Now, what you're going to find is most attorneys are gun shy about giving real numbers, partly because I think lawyers are always afraid of being sued, and partly because there's no bright line test for most things in family law. There's not a calculation to find out how long or how much you pay in alimony. So they're reluctant to give a number because then clients rely on that number and they get upset when the number turns out to be different later. But I do believe, and I usually recommend or offer to my consultation clients, a range of what to expect for alimony. I mean, we know whether it's going to be 2 years or 20 years. And we might not know whether it's going to be 8 or 12, but we know if it's going to be short or permanent, which we call open durational. We have some sense of child support, even though it's done by a guideline, which we'll talk about. We can basically give some range of expert and legal fees. Those are the topics that are a little more difficult to give an estimate, and they're obviously the more important ones that you want, which is unfortunate, but that's just the way that things are. But you should be able to get a range. If you cannot get a range, you might want to consider using somebody else for your case. 3, communication and availability. Ask how the attorney communicates with their clients and their ability to answer questions and provide updates. And this you want to ask not just about how they answer or what you can expect, but you want to find out, are you going to get their cell phone numbers? Are you going to be able to text message them? Is the staff going to be as accessible and responsive? Do you get charged every time that you send a text message or not? You also want to know about that. And what is the time frame you can expect to get a response. Some lawyers promise within 24 hours and some don't promise anything. You want to know what to expect. Divorces, in many cases, can be very emotionally challenging, costly, and the most important things in your life are at stake. You want to know that the person that you're dealing with is going to be responsive to your needs. Understanding legal fees and costs. Let's expand on that a little bit and talk about some options. First, hourly fees versus flat fee. Learn the different fee structures and understand how your attorney bills for their services. Now, I'll put right out here, I don't offer flat fees for divorces. I believe that those who do are providing a disservice to their clients. And quite honestly, it's a business. So if you're charging a flat fee for a service, my opinion is the service provider, the attorney, is looking to do as little as possible and make as much as possible. And conversely, the client is looking to get as much as possible and pay as little as possible. So it's an immediate conflict of interest between the two people most important to cooperate and work together well. And I also find that people come to me after being promised a flat fee, didn't understand what it did and didn't include. By a caveat, the agreement you receive, if it is a flat fee, should specifically say what it does and does not include. But trust me, most lawyers are not going to do a flat fee agreement at your initial consultation if there's any chance that you're going to go to a trial. So right off the bat, you're either getting a lawyer who's not planning to take you to trial if need be, or is going to charge you more than the flat fee anyway. So again, I urge you to be very crystal clear with your lawyers, read your paperwork and the retainer agreement that you must be provided by your attorneys, which is required, so that you understand what your fee structure is. Additional expenses. Be aware of potential additional expenses such as court filing fees, expert witness fees, and administrative costs. Along that, I mean, of course, that's pretty clear, I think, in what we're discussing, but also think about and ask whether or not you're likely to have any child custody related fees like counseling or experts or testimony, transcripts, deposition costs, things like that. Find out based on the complexity and issues of your case, whether or not you're likely to incur these kinds of costs and what they're likely to be. Lastly, payment arrangements. Discuss payment arrangements. Include retainer fees, payment plans, and any available financing option. Now, every firm and every lawyer is going to be different. I personally don't know anything about financing options when it says payment plans, but some may provide that. We do not at the Micklin Law Group, but certainly you want to look at all of your options. You may also want to talk independently, or I mean, I guess you could ask the lawyer, but you speak independently to banks and loan officers, because divorces, quite honestly, can be a very substantial undertaking. And while that may dissuade people from wanting to follow my advice, or may even dissuade you from hiring my firm, doesn't change that fact. And you want to be prepared. You want to be properly financed. You don't want to run out of money and then beginning to make decisions based on the lack of fees as opposed to what's best for you and your family. But if you don't have proper financing and understand your arrangements and your potential expenses, you're going to run into problems and you're going to end up having to compromise very important issues. Child custody and support considerations, probably the most important and challenging aspects of any divorce. First, you want to know types of custody. Explore the different types of custody arrangements, including sole custody, joint custody, and parenting and visitation rights. Now, there are many types of custody terms. There's sole and joint physical, there's sole and joint legal, there's primary, parent of primary residence, parent of alternate residence. I generally tell my clients, don't use terms. Discuss what you're looking for. Talk about things in the terms of decision-making, overnight schedules, vacations, and holidays, things like that. When you ask for a term, when you're trying to use a term, if you use the wrong one, you may first get the wrong thing, but you also may convey the wrong idea or message to both your attorney and to the judge of your case. Next, child support guidelines. Understand how the child support guideline is calculated in New Jersey and the factors that determine the amount. Now, the interesting thing about our guidelines in New Jersey first is it's done by a calculation, a guideline. You plug in your incomes, your overnight schedules, parenting schedule, recurring medical costs, daycare costs, health care costs for a family plan if you have that, and it calculates a specific number. Two things to know about this guideline, and again, I do have a separate webinar I'll try to put a link to, but if not, again, you can search child support guidelines, what to include and what is not included. It requires that you file something called a case information statement, which is a very tedious, complicated document that is not actually used by most judges when calculating child support, but it's required anyway. Don't ask me why. So you might want to look at that form, maybe even get a copy during your initial consultation from your lawyer so you can start filling it out, make sure it's accurate. I tell everybody it's a summary document, so it doesn't have to be precise, but it should be accurate. Now, I know those two words are a shade of gray away from another, but meaning you don't have to, because you don't have to know exactly how much you spend on hair care in a month, but you need to be fairly accurate. So use as much information as you can and be as accurate as you can. The last thing to know about child support guidelines in New Jersey is there is a basis to deviate from them. If you have or the other parent has extraordinary expenses or does not have the common extraordinary expenses, like they live with their parents and they don't pay any rent or utilities and no cable bills. Child could have a special talent that needs to be factored in or a medical need that has a cost that should be included. So you can and you should understand the reasons for deviating from child support guidelines. And lastly, on custody and support considerations, modifications and enforcement, learn about the processes for modifying child custody and support orders and enforcing them if necessary. And this is important in your initial consultation because, in my opinion, the enforcement process in New Jersey is very weak. I shouldn't say weak. It's going to depend on the case. But if you have a high conflict case or you have a spouse or a partner that is not afraid of violating the law, not afraid of a court order, narcissistic personalities are very well known for that. And I do have a great deal of experience with that and some very popular webinars on those also. If you believe you're going to have a partner that does not comply, in addition to learning the modification and enforcement, you also want to know what you should be building into the orders that you're getting in the first place to avoid this problem. For instance, there are generally provisions about payment of legal fees, but most lawyers will put in things like payment of reasonable legal fees. Well, if you call it reasonable, then a court can give you less than all of them. If you make sure your agreement says the defaulting party pays all legal fees, then there's no question. You will get all of your legal fees. You've taken the discretion away from the judge. But these things are important initially, not post-judgment, not when you're seeking to enforce them. So find out from your lawyer what needs to be put into your agreements and your orders to ensure that modifying or enforcing them in the future will be easier for you. Options for alternate dispute resolution. Everybody thinks divorces are jot down ugly court battles and trials, which they're not. They usually will settle through either mediation, collaborative divorce, or arbitration. Mediation. Discuss how mediation can help resolve divorce issues amicably and with the help of a neutral third party. The divorce process in New Jersey is largely based in mediation processes that are court-sponsored. If you have custody issues, you will be sent to custody and parenting mediation with the court's mediators, so it's not out of your pocket. In your divorce process, the court will send you to several mediation hearings, including an early settlement panel and intensive settlement conferences, both which are sort of court-sponsored or with court staff or even your judge. They're not out-of-pocket costs to you. If these are unsuccessful, or there are some issues that remain following them, you will also be sent to what's called economic mediation. This is where you may pay some out-of-pocket fees. A court-sponsored attorney who offers to do mediation will provide 2 hours of free mediation time. The first hour usually is review and preparation of the file, and the second hour is the first hour of your mediation. That will be free, usually. After that, you will be paying hourly. I usually tell my clients, if in the first hour you don't think you're going somewhere, end it so that you're not paying. I mean, you can generally tell inside of the first hour if you're making progress and it's worth investing fees into that. Because remember, whatever you do in mediation, your lawyers are going to need to review. So you're going to be paying fees to review what you did. Make sure you're spending quality time with the mediator. Collaborative divorce process. Explore the benefits of collaborative divorce where both parties work together to find mutually agreeable solutions. The thing to know about collaborative divorce is it is a confidential proceeding or process, I should say, where your lawyers and whatever experts you've hired have agreed to work together for what should be similar goals and outcomes. And the purpose of the process is to find out the best way to reach those goals and outcomes. It's also important to know if you do not reach a resolution to your divorce, all of the people, lawyers, and experts that you've utilized in this process are conflicted out from your divorce case, which is good and bad. I mean, it's good in the sense that you get everybody committed and working hard. It's bad because you may have invested a significant amount of money in all these people and you can't use any of it. So my caveat for a collaborative divorce, I'm not a huge fan of it currently. If we ever meet to talk, you can ask me why. I won't go into it here. But you're going to invest a lot in there and then you're starting over. So make sure that when they speak of shared goals and outcomes, that they really are. I always say, for instance, I put out a couple of things like, hey, are you willing to talk about my client having custody of the children? Like if I'm representing a father, and commonly and traditionally, most women that I've encountered aren't willing to openly and easily engage in a discussion about equal time. And I say, well, is your client going to discuss equal time? Is your client going to discuss my client having primary time? If the answer is no, then it's not a collaborative process. If they're already coming into the process with things that they are unwilling to discuss, you don't have shared goals, don't invest the time or money. Arbitration, probably my preferred and most favorite choice of alternate dispute resolutions. You want to understand the process of arbitration and how it can provide a more private and efficient resolution to divorce disputes. Now, this can be binding or non-binding. You also have to understand the certain limitations about the rights that you're giving up and the appeal process. That being said, I find binding arbitration to be a very positive way to resolve divorces. It's faster and a lot less expensive than a trial. Generally, and again, how this all works is beyond the scope of this webinar, but if you do it right and you have a retired family court judge, you're getting a similar type of process as you would from a divorce, but yet faster and cheaper and with dates that are certain. Anybody who's been through a divorce trial will know exactly what I'm talking about. But so, again, I do have webinars on the different types of alternate dispute resolution. You can go to my website and YouTube page for them. Again, I will try to get links to them below. I don't handle that part. That's why I keep saying I hope to, but that's sort of out of my hands. But you can always find them on my website and my YouTube page. How to prepare for the divorce attorney-client relationship. First, open communication. Learn how to establish open and honest communication with your lawyer to ensure a strong attorney-client relationship. I always tell people, go with your gut. If you don't think that you're the right fit with that client or with that attorney, then don't. I tell a lot of my clients in consultations, I don't think we're the right fit for you, for whatever the reason may be, a difference in personality, a difference in goals. You may take positions that I find are unreasonable or unsupported that I cannot help you with. I'll tell you right out of the gate. And you want to make sure that you ask your attorney, can you advocate for these positions? Do you think that my outcomes or my goals are reasonable or achievable? Start the open communication during your first meeting. 2, trust and confidentiality. Understand the importance of trust and confidentiality in the attorney-client relationship and how it benefits your case. Now, basically, from the moment you call the lawyer's office to schedule an appointment to the end of the consultation is all confidential. They cannot tell anybody anything about your case. You will find sometimes when you call, you'll be told from an attorney there's a conflict and you can't even be heard. They won't tell you what the conflict is. That generally means they've spoken to your adversary, your spouse, or your partner. But they cannot say that. But everything you discuss is confidential. You want to understand there are some limitations to confidentiality. Don't get me wrong. You can't. Well, I'm not even going to give you examples because I don't want to go into ludicrousy, but there are limits to it. You might want to ask, what are the limitations? What will happen if this is done? What will happen if I have unreported income, for instance, which is very common? How does that impact the confidential relationship between you and your attorney? And 3, active participation. Discover how actively participating in your case can contribute to the success of your divorce proceedings. This is important because a lot of clients will come and say things like, well, if I make photocopies, will that help? Can I draft the certification and then you just edit it? I can help with mailings, things like that. Now, in my experience, this generally is not very helpful. Clients think it is. They think it's going to save them fees and costs, but it doesn't usually work out that way. It ends up being that we take more time in either putting the information in the format that it needs to be or fixing the work that was done than we would have if we just did it ourselves. But that's not with every case, and it's certainly not with every attorney. So find out from whomever you're meeting with, how much can you participate? How much are you even willing to participate? What the limits are, and will that benefit your case? Okay, contacting the Micklin Law Group. If you need assistance with a family law matter, you can contact me, Brad Micklin. You can visit our website at micklinlawgroup.com. That's MICKLINLAWGROUP.com. You can call us at 973-562-0100. Our YouTube page, as I referenced countless times throughout this, is just under my name, Brad Micklin, again, MICKLIN. You will find that my webinar has my website has a link to send me a text message directly. That doesn't mean that I can necessarily answer it, depending on the nature of our relationship and the question asked, but it's up there to give you accessibility to me. And if I can answer or help you, I certainly will do so. My website and my email signature line also has a link to my virtual calendar, which you can schedule meetings. If you have not been through the intake process, of course, you will then need to complete it, but you can get a spot on my calendar. You can see my availability as well as the times that I hold meetings so that we can do our best to help you. Social media and YouTube, as I've said probably ad nauseum, here is the link. I don't know if the link will help you because I'm not sure when you're watching this if you can cut and paste or not. But again, you can also just type my name as it's spelled there with the middle name Michael and get to my YouTube page. I do have a Facebook page for the Micklin Law Group that we do post webinars, blogs, and other information that should help you. I am also on LinkedIn, not very active. I'm on Twitter, not very active. So the Facebook page is probably the best page. My YouTube page is by far the best page because I actually do interact with clients and consultations also through that medium. I'm not going to read this at length. I'll leave this disclaimer up for you just to understand basically that this is not legal information that you can rely upon. It is advertising information under the New Jersey ethical guidelines. This does not create a relationship, attorney-client relationship. It is simply here as information to assist that you need to speak with an attorney before you move forward. With that, I hope this information helps you. I am always accessible, as I said, through the various contact methods. If you have more questions or if you'd like a consultation, if you're a client, I hope this was also helpful. And of course, you know how to get in touch with me. With that, I wish you all good luck, and I'm going to sign off.